Good afternoon, happy Tuesday, and thank you so much for being here with us today for our pro-choice check-in. My name is Rebecca Hart-Holder. I'm the Executive Director of NARAL Pro-Choice Massachusetts, the Commonwealth's leading grassroots pro-choice advocacy organization. And to everybody who joined for our inaugural pro-choice check-in last week, welcome back. And for those of you joining us for the first time, thanks so much for being here. Last week, we had a great conversation with Dr. Cheryl Hamblin, OBGYN who practices in Massachusetts and Mississippi, and we had over 50 people attend. This week, we're going to have a really interesting conversation with my friend and colleague, Stephanie Toti, about the state of reproductive freedom during the COVID-19 pandemic and the June v. Russo case. And we have had over 125 people sign up for this session. So we're really excited about that. A little bit of housekeeping before we get started. Like many of you, I'm working from home and sharing childcare duties with my wife. So forgive any interruptions you might hear. I have once again commandeered my 5-year-old's bedroom for this call, and she may need to procure a fairy or a stuffed bunny while I am in here. So don't be surprised if you hear a little bit of noise. And as you will remember from last week, for those of you who are with us, we're using webinar mode so that the video and audio feeds are muted for everyone except for our panelists. And we did this for unfortunate reasons because of Zoom bombing. We'd rather see your faces on video. It makes for a much more interactive session. But Kate Freilich and John Latino are working really hard behind the scenes to make sure this can be as interactive an experience as possible. So to the right of your screen, you'll find a chat box. If you have any technical issues, use the chat box to let us know, and Kate and John will do their best to help you. And in the middle of your screen towards the bottom, you're going to see a question and answer icon. If at any point you have questions for me or for Stephanie, you can submit them there. And we'll be saving about 15 minutes at the end to answer your questions. So be sure to send them in throughout our conversation, and we'll try to get all of them heard, and Kate will pop in at the end to help us facilitate that session. I also want to remind you to follow us on social media. You can find links to Facebook, Twitter, and Instagram in the chat box. And that's the best way to stay up to date on future events and check-ins and any important updates and announcements that we have about reproductive freedom in Massachusetts. And with that, I think we're ready to kick it off. So grab your coffee. Here we go. So as many of you know, the anti-choice movement has a playbook. They pass radical anti-choice laws in states unfriendly to abortion care, while simultaneously working to fill the courts with judges committed to overturning Roe v. Wade. And they are very committed to using every tool at their disposal to find a way to take us back to a time before Roe. Today, the attack has come in the form of abortion bans, allegedly to protect public health during the COVID-19 pandemic, but really they're a naked attempt to outlaw abortion. To date, 13 states have attempted to restrict abortion access during the pandemic by claiming that it's an elective procedure or by spreading falsehoods that it wastes personal protective equipment and puts patients at greater risk. Texas has drawn the most attention for its COVID-19 related abortion restrictions, and the Texas ban is currently being litigated. And as it stands today, people in Texas can obtain a surgical or aspiration abortion if they're close to the legal gestational limit to obtain that care, or they can use medication abortion to get abortion care earlier in pregnancy. And in early March, as many of you know, the Supreme Court heard arguments in a case called June v. Russo about an anti-choice Louisiana law, which, if the High Court finds the law constitutional, would force all but one of the state's clinics to close and open the door for other states to declare open season on reproductive freedom by passing similar restrictions that undermine Roe. The law in question in June v. Russo is nearly identical to the Texas law found unconstitutional in Whole Women's Health that requires clinicians to have admitting privileges at local hospitals. So here with us to discuss all of this is attorney Stephanie Toti. Stephanie was lead counsel on the legal team that successfully argued Whole Women's Health at the Supreme Court. She currently serves as senior counsel and project director at the Lawyering Project, which she founded in 2017. And the Lawyering Project aims to improve access to reproductive health care through litigation that advances a really truly intersectional framework. Prior to founding the Lawyering Project, Stephanie spent 10 years at the Center for Reproductive Rights, where I was lucky enough to cut my teeth under her tutelage. She's also part of the legal team litigating the COVID-19 ban in Texas, and we're absolutely delighted to have her here today. Welcome, Stephanie.
Thank you so much, Becca, and thank you to the whole team at NARAL for inviting me to be part of this check-in today. I'm really excited about it. And I will just note that I'm not actually in San Francisco at the moment. I'm based in New York, but I was looking for a virtual change of scenery. So I'm in front of the Golden Gate Bridge today.
We can all relate to that feeling these days. So let's actually just start out with how you're doing. You're in New York, and I wonder how you're holding up in the epicenter of the pandemic.
Thank you for asking. I'm doing okay. For several weeks, I was in Brooklyn, just holed up with my cat. And then I decided to come out to my parents' house. They live in Nassau County, which is just outside New York City. So I self-isolated for 14 days so I could make sure I wouldn't be a threat. And now at least I've got some company out here, and they have a yard, which is nice, which is something I was really lacking in Brooklyn, some outdoor space that I could utilize while appropriately socially distancing.
Yeah,
so
it does a lot for your mental health to have that outside space.
Yeah, definitely. But thank you.
So let's just kick it off by having you tell us a little bit about the Lawyering Project and the kind of work that you are trying to do there.
Sure. The Lawyering Project is a small nonprofit organization that's focused on legal advocacy to advance reproductive rights throughout the U.S. And we kind of pride ourselves on being a laboratory for innovation. So because we are a relatively small and pretty new group, we were founded in 2017, shortly after the Supreme Court's decision in Whole Woman's Health v. Hellerstedt, but also following the last presidential election. We kind of came together with the idea that this was a good moment in time to experiment with some non-traditional forms of litigation, some new legal theories, to bring some new litigants into the mix in order to try to highlight and really shine the spotlight on the folks who are most affected by restrictive abortion laws. And so a lot of our litigation does, of course, involve abortion providers, healthcare providers, doctors, nurses, and so on. But we also really try to bring in other folks who are impacted, including people seeking access to abortion care and abortion funds and practical support networks who are working with those who have the fewest resources, trying to gain access to care, working with the most vulnerable populations, and really have an important perspective to bring on how restrictive abortion laws impact those communities especially. So that's what we're up to, and we have cases kind of all across the country challenging restrictive abortion laws, and for the most part we have focused on laws that have been on the books for a while, kind of things that we've come to take for granted in many places as just part of the status quo, like biased counseling laws, parental involvement laws, mandatory waiting periods, those kinds of things. But we have recently been involved in some of this rapid response litigation concerning what I've been calling the COVID bans, the COVID abortion bans, attempts by the states that Becca mentioned to try to ban or severely restrict access to abortion during the current public health crisis.
And important to note, the Lawyering Project was really helpful to NARAL Massachusetts when we were working on repealing the Massachusetts pre-Roe criminal abortion ban, and did some really helpful and excellent research for us on that. So happy to keep our partnership going.
Yes.
So I think we'll start today by talking about the COVID bans, and then we'll go to June v. Russo. But I wanted to, before we dive into that kind of nitty gritty about the cases, I wonder if you could just tell me a little bit about how the courts are functioning and how you're actually practicing right now. Are you able to get papers signed, notarized? How are you actually lawyering?
Sure. So the court system has also been disrupted by the pandemic, and most courts across the country have shut their doors to in-person hearings and proceedings. So a lot of court practice is going on telephonically or online, by Zoom or other platforms similar to this meeting, which has been very interesting because judges, particularly in the federal courts, tend to be more experienced individuals and not always the most comfortable with the latest technology. And so it's been an interesting adjustment for everyone, but but we're all trying to make it work. I've had several telephonic court hearings, in the last few weeks. I've done a few depositions by video conference. I have an upcoming appellate hearing next week that's going to be by video, which should be interesting. But of course, all of these innovations sometimes still get, interact with some of the court's more anachronistic rules about having things notarized and having original signatures. And the some of the court administrative staff in particular has been a little slow to let go of some of those requirements that they're so used to enforcing. So there was some document that I had to file recently where the clerk's office wouldn't waive the ink signature requirement. And I needed a colleague to sign it. So I have in my home setup, I have a printer and a scanner. But my colleague in North Carolina did not. And so I had to print out this document in Brooklyn, mail it to her so she could sign it and mail it back to me so that I could scan it and then upload it to the electronic docket. Just silly. And I imagine as time goes on, if we continue to be dealing with these mitigation measures, that those requirements will continue to be relaxed, and hopefully no one will have to get anything notarized anymore, or everyone will move to an electronic notary system. But for now, there's still kind of a push-pull between the...
A learning curve.
Exactly.
All right, so let's talk about the COVID bans. Can you give us an overview of the bans and how they're making their way through the courts right now?
Sure. So you mentioned that there were 13 states that tried to take some action to restrict abortion. In 5 of those states, advocates were able to basically work out a settlement with the state attorneys general to allow abortion care to go forward on, based on the exercise of a clinician's medical judgment. So clinicians have to make a determination that this particular abortion isn't likely to consume copious amounts of personal protective equipment or PPE, and that delaying it would be harmful to the patient. And of course, delaying any abortion is going to be harmful to the patient. But in the remaining 8 states, there has been litigation, and in the majority of those states, the courts have stepped in to block the state action in whole or in part. So except for Texas, I'm going to put Texas aside for a second, all of the other states where there's litigation are currently allowing medication abortion to go forward as a result of court orders in those cases. And in several of those states, procedural abortion is also going forward, either fully or in certain circumstances. So some courts have said someone's nearing the gestational age limit for abortion, then they can have their procedure. if someone is nearing the boundary between first trimester and second trimester, they can go ahead and have their procedure. So different courts have kind of put different limitations and qualifications on it, but have enabled at least a fair amount of abortion care to go forward. Now, of course, everybody that's denied access to abortion or delayed in their access suffers, a serious harm. And so I don't want to minimize the fact that there are some people in those states who are currently having to wait. But the litigation in those states is going forward to try to ensure that everybody can have timely access, and in the meantime ensure that there's not too big a backlog, so that as access expands, people are able to get their care right away and don't have to wait, because now there's if in a given week there would have been 100 people trying to access care, now there's 500 people because so many people were prohibited. So we're trying to make sure that as many folks can get their care now as possible, and reduce the restrictions as much as we can going forward. Texas has been a real roller coaster, and it's a bit of an exception to the rule. You mentioned that folks in Texas can currently access medication abortion, and that was the case prior to yesterday afternoon. But the appeals court that is involved in the Texas litigation, the Fifth Circuit Court of Appeals, issued an order yesterday basically dissolving the portion of a temporary restraining order that allowed medication abortion to proceed. And so once again, there's no medication abortion happening in Texas, and the only procedural abortions that are currently allowed are for people who are approaching the gestational limit for abortion, which is 22 weeks in Texas.
And will you talk us through kind of the chronology of the Texas case? Because I know it went up to the Supreme Court, then it went back down. And I think it would be really helpful to kind of hear an overview from folks about kind of how that case is ping-ponged through the system. But that's really shocking that, well, maybe not shocking because it's the Fifth Circuit, but nevertheless shocking to me that even medication abortion is out of reach for people in Texas.
Yeah, it's really heartbreaking because it's been such an emotional roller coaster for folks trying to access care. And the way it all unfolded is that on March 22nd, the Texas governor, Greg Abbott, issued an executive order prohibiting elective procedures and calling on healthcare providers to limit any surgery or procedure that was going to deplete PPE supplies necessary to deal with COVID. But there were exceptions in the order for procedures that were time sensitive or in a, clinician's medical judgment should go forward or else would risk harm to the patient. So initially, we thought that abortion providers were fine under the executive order and just had to make those case-by-case determinations for each patient. But then a couple of days later, the Texas Attorney General issued a statement saying that he understood the executive order to categorically ban all abortion, and that he would vigorously enforce the order against any provider that continued to provide abortion care. And so that, of course, had a big chilling effect on
and did that include
providers.
Criminal penalties?
Yes.
Yeah.
There are criminal penalties. There are also licensure penalties. So a doctor or a nurse who are involved in abortion care could lose their license to practice, and a clinic that's providing abortion care could lose its license under state law, as well as incur pretty substantial fines. So there's a range of penalties, all of them quite serious and quite scary. So as a result of this, many providers stopped providing care, and we filed a lawsuit to challenge the executive order in court. And then there were a series of temporary restraining orders that were issued by the trial court judge, but then the appeal court, the state sought an emergency appeal to the Fifth Circuit Court of Appeals. If there are any lawyers on the phone, you might know that technically a TRO is not appealable. The state filed something called a petition for a writ of mandamus, which is a very archaic procedure, basically telling the appeals court that this was such an emergency that they needed to depart from the normal appellate procedures to deal with it. The appeals court, which is super conservative and super anti-choice, blocked those TROs each time within a matter of days. So there would be like a 24-hour period where clinics could schedule patients for abortion care. And in Texas, there's a 24-hour waiting period and a 2-trip requirement. So patients would come in for the first day of their mandatory consultation, and then the court would issue an order saying, but now they're blocked from getting their actual abortion the next day. And this, this happened several times. So, like, we went back, we asked for another TRO on different grounds, each time trying to meet the requirements that the appeals court said would be necessary, to show that we were entitled to a TRO. And then each time the appeals court just gaslighting us and saying, no, we never, that's not what we meant, or we didn't say that, or, and so, there have been a couple of successive TROs that were entered and then dissolved by the Court of Appeals. And the impact really on both the patients and the clinic staff who have had to, deal with, be the ones to call the patients and say, I'm so sorry, we have to cancel your appointment. It's just taken such an emotional toll on all those folks who are directly involved. But so where we stand today is that the original executive order is set to expire at the end of the day today at midnight. And then there's a new executive order that's going to take effect at midnight tonight. And the new executive order provides some additional exemptions, generally applicable exemptions if healthcare providers certify that they'll reserve a certain percentage of any hospital capacity that they have for COVID patients, and that they won't request any PPE from the federal, state, or local government. Then they're able to resume providing elective procedures, quote unquote elective procedures. But the state hasn't taken a position yet on whether abortion providers are, even if they make those certifications, if they're eligible for the exemption. So we're continuing to move forward with the litigation. We did go up to the Supreme Court at one point last week after one of the TROs was dissolved. And after we filed our application with the Supreme Court, the Court of Appeals issued a revised opinion saying that it would allow medication abortion to go forward. And so there were several days where medication abortion was able to go forward. But then once we withdrew our application from the Supreme Court, they issued another order saying, actually, no, medication abortion can't go forward anymore. So there's really not even the pretense of kind of fair play at that court anymore, which is incredibly frustrating and maddening and disappointing. But
not surprising.
Right, but not all that surprising, given the current composition of the court. But we are continuing to fight in Texas on every front, and we are trying to work with the Attorney General's office to get an understanding, a written agreement that abortion providers can utilize that new certification process. But we're also moving forward in the trial court to try to get a preliminary injunction to block the new executive order. And we're prepared, to go back up to the Supreme Court if we have to, in order to ensure that people will have timely access to abortion in Texas going forward.
What's your hunch on whether or not it'll make its way to the Supreme Court?
I would say it's 50-50 at this point. I think if the state is willing to allow abortion providers to use the new certification process, then I think we won't need to go to the Supreme Court, except maybe to ask the court to vacate, which is kind of a technical legal term for undo some of those bad decisions that the Fifth Circuit already issued. But that would be a sort of a technical request. It wouldn't result in, kind of oral argument and a whole case in front of the court. But if the state is unwilling to allow abortion providers to utilize the new certification process, then I think I think it's very likely that we'll have to go back to the Supreme Court.
So I'm going to ask you one more kind of technical legal question about the Texas ban, and then I'll ask you maybe one or two more questions about the Texas ban after that, and we'll transition to June v. Russo, because I'm mindful of time. In reading some of the papers, I know that the conservative states are trying to get the courts to adopt a framework that says that the right to abortion has to yield to a public health emergency. And they're citing the 1905 case, Jacobson versus Massachusetts. So can you just tell us a little bit about why this, what Texas is arguing and why it's such a dangerous argument?
Yes. So Jacobson is a case about mandatory vaccination, and Massachusetts had enacted a law that everybody needs to get vaccinated for smallpox, and there were some individuals, some early anti-vaxxers who didn't want to comply and who sued, saying that it violates both their religious rights and their rights to bodily integrity. And the court said that the public health crisis surrounding smallpox was a sufficient reason, it was severe enough that it justified the state's action in mandating vaccination. Texas is trying to use that precedent, and other states are as well, to say that basically executives at both the state and federal level have unlimited authority to override people's constitutional rights in a time of national emergency. And clearly that's a very dangerous precedent. And the argument that they're making is far broader than what the court allowed in Jacobson, and the implications of it are far scarier. For one thing, in these abortion cases, there's actually no fit between banning abortion and trying to preserve PPE, because someone who's pregnant who doesn't have an abortion is going to remain pregnant and will need medical care regardless. Pregnant people need medical care all throughout pregnancy, and the longer that someone remains pregnant, the more care that they're going to need. And so people still need ultrasounds, people need blood tests and other lab tests. People at some point are going to start needing prenatal care. And of course, for folks who ultimately have an abortion but are delayed in accessing abortion, at each stage of pregnancy, an abortion procedure requires more PPE. So medication abortion, which can happen early in pregnancy, doesn't require any PPE at all, because it's possible for the provider and the patient to socially distance. You could be 6 feet apart while you're counseling a patient, and then, put down the pills and the patient picks up the pills, and no PPE is required. But early procedural abortion requires some PPE. Later procedural abortion requires more PPE because it's a more complicated procedure that requires more medical personnel to be involved. So the state's action in prohibiting or delaying abortion doesn't actually serve its stated interest. And so what Texas has tried to argue, and what some other states has tried to argue, is that the courts shouldn't concern themselves about those details. They should just take the government's word for it, that they know best. and that the court shouldn't scrutinize the details to make sure that the government program is actually well designed to meet the emergency circumstances. And so that, that has been a principal argument for abortion advocates, is that this just doesn't make any sense. Even if the government does have some additional powers in the time of emergency, they can only deploy those powers if in a way that's actually going to help mitigate the crisis. And here it's not.
Right.
So that's how that argument has been playing out.
And kind of keeping on the Massachusetts theme, Governor Baker announced an elective surgery ban very, very early on in the pandemic in mid-March. And, NARAL Massachusetts moved really quickly to advocate with the executive branch that abortion could not be included in the elective surgery ban, in part because I think we saw the writing on the wall and we knew what would happen in states hostile to abortion care. And I'm curious if states like Massachusetts, who have protected access during the pandemic, have been helpful to you in your arguments.
Yes, absolutely. Massachusetts has really been a leader on this front. There are some other states as well that have come forward and explicitly acknowledged that abortion is not an elective procedure, that it's time sensitive, and for someone who doesn't want to give birth to a child, it's the only option. So it's not elective in the same way that a knee replacement might be elective, or some other procedure might be that you could, postpone for 6 months or a year without really jeopardizing your underlying health, or or it becoming moot. I mean, obviously, pregnancy is a time-limited occurrence, and for someone who's pregnant, you don't have the option of maintaining the status quo. So you can't just continue whatever other treatment you might currently be on before, moving to the procedure. It's your only option. Mm-hmm. And so for the states that have recognized that, it's been really valuable to point that out in litigation with the states that haven't recognized it. And there have also been several major medical associations to come forward and issue strong statements to that effect as well, including the American College of Obstetricians and Gynecologists.
Are you hearing from providers, and this will be my last question on the COVID bans, but are you hearing from providers on the ground in states like Texas that there's been an increase of people traveling out of state, an increase in self-managed abortion? I'm curious what the providers are telling you the real life impact is on people.
Yes, absolutely. So there has definitely been a documented increase in people traveling to other states. And this also undermines the asserted purpose of these executive orders to begin with, because by engaging in long distance travel, people are increasing the likelihood of COVID transmission. Mm-hmm. And so we've been working with the abortion funds in Texas to document all of the places where they have helped folks travel to. And I mean, some people have traveled, as far away as Seattle and Georgia, which are also hot spots for the virus, and they not only risk themselves contracting the virus, but then they're going to bring it back to their communities. There are also a lot of folks who have been traveling to neighboring states like New Mexico, to the point that there's now typically those clinics in New Mexico have a waiting time for appointments less than a week. You can get an appointment within the week. Right now, some of them are up to 4 weeks to get an appointment. They're booked out for 4 weeks because of this huge influx of Texas patients coming in to get care in New Mexico. So.
Well, and that's the tell, right? That's the tell that it's not really about protecting people from the pandemic. It's about banning abortion. It never has been about protecting people from the pandemic.
Right, exactly.
So let's talk about June v. Russo and the future of abortion rights. And I'll ask you to kind of look into your crystal ball a little bit. I don't think there's anybody else in the country who can do that better than you can. So maybe start by telling us about the whole women's health case. I'd love it if you talked a little bit about what it was like to argue before the court, and then if you could tell us about the June v. Russo case.
Sure. So the Supreme Court heard Whole Women's Health v. Hellerstedt in 2016, and that case concerned a pair of Texas laws. One that required all doctors who provide abortions in Texas to have admitting privileges at a local hospital, even though doctors providing other outpatient procedures didn't have to have admitting privileges. And the other law required all abortion clinics to meet the licensing standards of ambulatory surgical centers, which are essentially miniature hospitals with operating rooms that are designed for procedures that are far more complex than abortion. And so the court ended up striking both of those laws down, saying that they imposed heavy burdens on abortion access, that they were going to force dozens of abortion clinics to close and prevent many people in Texas from getting timely access to abortion care, but didn't provide any medical benefits that were going to justify those heavy burdens. That basically neither requirement made abortion safer. Abortion is already safe, very safe, and neither requirement would enhance the safety of abortion or provide any other benefit to someone seeking abortion care that would justify all of these heavy burdens. And so the court said, as a result of that, the requirements are unconstitutional. I had the privilege of arguing that case to the Supreme Court, and it was the first time I argued at the court, and I would say that it was both equal parts thrilling and terrifying. It was a lot of fun to be at the court and a tremendous experience, but also very intimidating. And I practiced for, it was an expedited timeline for that case. So I didn't quite have months to practice, but I practiced for weeks and pretty much all day, every day. All I did was moot Supreme Court arguments. But
including here in Boston.
Yes, that's right.
Yeah. Oh, sorry. Go ahead, Stephanie.
Oh, no, I was just going to say, yeah. And I had the opportunity to come up to Boston and to moot with some very experienced Supreme Court lawyers, and also moot in a public forum. And it was really great.
And did you walk out of the oral arguments thinking that you could read the tea leaves, or did you feel like you just weren't sure which way the court was going to go?
I left feeling optimistic, but definitely not counting any chickens. And I feel like oral argument can sometimes give you some insight into where the court is going, but it's never a guarantee. After the oral argument, the justices go back into their conference room and meet with each other and hash things out. And what happens in that space can alter, where any particular justice is leaning. So you never know for sure what's going to happen until you get the decision. But I was feeling cautiously optimistic after the argument.
One of the best books I've read about the court and kind of a bird's eye view into what those conferences look like after arguments is Becoming Justice Blackmun, which if folks haven't read is just a wonderful account. So tell us, I'm gonna try to open up the questions. We'll go 5 more minutes, so you and I will go quickly through June v. Russo. But tell us about June v. Russo and why it's so troubling that the court has taken this case.
Yes, so June v. Russo concerns a Louisiana admitting privileges law that is identical to the Texas law that the court struck down just 4 years ago now. And so it's a little bit troubling that the court is hearing the case at all, that it didn't simply summarily reverse the Fifth Circuit, same circuit that oversees Texas, also oversees Louisiana. This Court of Appeals upheld the Louisiana admitting privileges law, notwithstanding the Supreme Court's decision in Whole Women's Health. And the Supreme Court could have simply summarily reversed that decision without having full briefing and oral argument. The court could have just said, this clearly violates precedent, and so it should be reversed. But instead, the court decided to take the case for full briefing and argument, and also to consider an additional issue about whether abortion providers should even be allowed to challenge restrictive abortion laws in the first instance, or whether those providers have a conflict of interest with their patients
Yeah, and
concerning those laws.
that part of the case hasn't gotten as much attention in the press, but I think it is equally troubling because, of course, third party standing, which is what you're describing, is critical to being able to challenge, anti-choice laws. Abortion providers need to be able to assert the rights of patients, because it's so difficult for patients to come forward, and if they are denied that opportunity, that is a serious blow to the ability to challenge anti-choice laws. Yeah.
Yeah.
And, if the court finds the Louisiana case constitutional, what do you think it means for the future of abortion rights?
I mean, there's a few different ways that the court could go. I think it's very unlikely that the court issues a decision that just overturns Roe v. Wade, or says there's no longer a right to abortion, for various reasons. If anybody wants to know more about that, we can talk about it in the Q&A, but it seems really unlikely to me. But it is possible that the court upholds the Louisiana law and says it's different from the Texas law in some way, or its impact is going to be different. So in Texas, the law was threatening to shutter dozens of clinics all across the state. In Louisiana, it's going to close a lot of clinics, but there aren't as many clinics because Louisiana is not as big a state. And so the court could say, well, it's not going to close as many clinics, so therefore it's not as big a deal. And what that would do is just mean that, advocates need to fight every law every time, that we can never, that states are just going to keep enacting these laws, and it's going to be like an endless Groundhog Day of challenging and challenging again and challenging again. It's also possible that the court could say that there's still a right to abortion, but the court in Whole Woman's Health gave too much weight to that right, and actually should have given more deference to the government's interests in restricting abortion. And so that could also give states more leeway in the future to enact restrictive laws. And so, those would be ways for the court to kind of set abortion rights back without taking a dramatic action like overturning Roe that would be sure to get lots of headlines.
Yeah, and just the idea that the court could overturn precedents that was decided just 4 years ago is terrifying, but really speaks to the power of the appointment, or rather the confirmation of Justice Kavanaugh to the court. I mean, that has had a profound impact on many of the social justice issues that we care deeply about, and especially abortion rights. Really quickly, and then I'm going to open it up. Why do you think it's so important that states like Massachusetts, fight to protect abortion rights and pass proactive legislation rather than, just playing defense?
Because as the Supreme Court allows states more leeway to restrict abortion, we're going to see even more people trying to travel from states like Texas to states like Massachusetts, where abortion is still widely available. And the easier that we can make it for folks to access care in those haven states, the better it's going to be. And I think the future of abortion rights advocacy is going to be a mix of litigation to try to mitigate the harms of restrictive laws, but also practical support to try to move individuals, help individuals travel to access care in places where it remains available.
All right, I'm going to ask Kate to hop back on. I'm mindful that I've gone a few minutes over the time I plan to open it up for questions. Kate, will you give us some of the questions?
Yeah, hi. Thank you so much for that incredible discussion. I learned a lot. We have quite a few questions. We'll try and get to as many as we can. The first one I'm going to ask is, why is it unlikely that the Supreme Court is going to straight up overturn Roe v. Wade?
Um, a couple of reasons. I think one is that the court, under the current Chief Justice, has shown itself to favor an incremental approach to changing the law, and overturning Roe would be, hugely dramatic, the opposite of incremental. And another reason is that the court's decision is likely to come at the end of this term, which would be late in June, and the next presidential election is in November, and for the court to overturn Roe just a few months before the presidential election could really have the effect of mobilizing voters. And I think that's, for the more strategic-minded justices who might, prefer to see Roe overturned, but also, are mindful that if a pro-choice president comes to office and a pro-choice Congress, that they could simply reinstate those protections legislatively. I think those justices might think twice about taking such a dramatic step for that reason.
Great, thank you. We have two fairly similar questions about restrictions on mifepristone, and knowing that there's 21 attorneys general who have requested the FDA to lift the restrictions, and just wondering, can either of you comment on if it looks likely that the FDA might act on that, or if advocates could file a lawsuit to require increased access?
So far, the FDA has indicated an unwillingness to budge, and they actually issued a statement, a few weeks ago, saying that they were not currently considering lifting any of the restrictions on access to mifepristone, which is one of the key medications used to provide medication abortion. That they were not, currently considering changing those restrictions. There is actually a lawsuit going on to lift those restrictions. It was filed in Hawaii in federal court. The restrictions on mifepristone include prohibiting it from being dispensed in a pharmacy. You can only get it directly from a prescriber, so you have to go to a doctor or a nurse practitioner or a similar healthcare provider with prescribing authority. You can't go to a pharmacy. And so because of Hawaii's geography, and some people, live in kind of remote areas that are only accessible by helicopter or boat, it's particularly burdensome. You also can't get it in the mail, whereas, normally you could get your prescriptions by mail order. That's not the case for mifepristone. So there is litigation going on to challenge those restrictions, but litigation often moves at the speed of like a tortoise. So it's not, the litigation isn't likely to yield any result that will be helpful during the current pandemic, but hopefully in the long run it will help to alleviate some of those restrictions.
Kate, maybe we have time for one or two more.
Yeah, here and then we have so many great questions. One more, and then I have one more, is how does the pandemic affect how the Supreme Court will come to their decision? Is the timeline going to be different, or do we still expect a decision in June?
Yeah, it's still likely that we'll get a decision before the end of June. Some people think it's actually possible that we might get a decision earlier than expected, because the Supreme Court has also altered its procedures. It's not having any in-court sessions anymore. It's moved to telephonic argument, and those telephonic arguments are going to be live streamed. But some folks think that because the justices are spending less time at the court, that they might get some of the decisions out sooner. But the court hasn't indicated that, so it's just speculation. So basically, that decision could come down anytime between now and the end of June.
Great, thanks. I have two more very quick questions. The first one is just a clarification. What is mooting? What is moot court?
Oh, moot court. It's a practice argument. It's just like a dress rehearsal. That's what a moot court is. So there's a bunch of lawyers who pretend to be the judges, and they pummel you with questions, as if you were arguing to the Supreme Court.
And they try to be meaner. They try to be tougher than the court will be, so that you're totally prepared. Although Stephanie, of course, was totally prepared.
That sounds super fun. One more question, which kind of wraps us up. In addition to, NARAL, what other organizations working on these issues are great for us to support and lift up?
I would say the abortion funds all across the country, because they are in addition to grassroots organizations like NARAL Pro-Choice Massachusetts, they're really at the front lines, dealing directly with individuals trying to access care. And right now there's just so much financial need between people having to travel and then people getting delayed in access to care, and abortions at later gestational ages are a lot more expensive than abortions at earlier gestational ages. There's the funds are doing a lot of great work, and I think could really benefit from both increased financial support, but also increased volunteer support to help with intake, to answer the phones, to help people make travel arrangements. So there's an organization called the National Network of Abortion Funds, NNAF, that's like an umbrella organization that can connect you with local funds, both in Massachusetts and in other states, if you wanted to, say, contribute to a fund in Texas or Louisiana or another part of the country where access is particularly challenged right now.
Yeah, we funds across the nation are doing a huge fundraiser right now. It's typically timed around this time of year, but pay special attention in Massachusetts to the Emma Fund, the Western Mass Abortion Fund, and the Jane Fund in Central Mass. They do really critically important work. And I know are helping with folks who are coming to Massachusetts from other states. So really important resources here in Massachusetts. All right, I'm going to wrap us up. I know I personally have many more questions for Stephanie, and I appreciate all of you who've submitted questions, and I'm sorry if we didn't get to all of them. A big thank you to Stephanie for taking time out of her really busy day to join us this afternoon. There are so many amazing legal advocates who make it their mission to protect the courts and to protect our rights, and it's a difficult and often really thankless job. And I think that discussions like this are important to remind and make really transparent just how critical their work is to protecting reproductive freedom. If you liked today's check-in and want to get more involved in NARAL, you can click on the volunteer link in the chat box to sign up for our volunteer list. We have some exciting volunteer events coming up in April, and Kate in particular has just done an outstanding job of transitioning us to the online world. On April 22nd, the ROACT Coalition is hosting a virtual coffee hour. On April 23rd, NARAL Mass is hosting a virtual movie night where we will be watching the really fantastic film Obvious Child. And our April volunteer meeting is going to be on the 29th. And if you want to continue to support our digital advocacy efforts during the COVID-19 pandemic, please consider donating to our digital organizing fund. You can find that link in the chat box. Like every other organization, we are finding ways to adapt to this new reality. And for us, that means continuing the fight for reproductive freedom online. Every little bit helps, even a donation of $5. And we're grateful for those of you who are able to give of your treasure. And I talked about social media. So definitely follow us on all those channels. And I hope you will join us again next Tuesday, April 28th at 2 p.m. We're going to have Mallory Schwartz, the Executive Director of NARAL Pro-Choice Missouri, and Amy Arambide, the Executive Director of NARAL Pro-Choice Texas, to really talk to us about the landscape of abortion access in Missouri and in Texas and how they're fighting back and how we can support them. So thank you all so much for joining us. I hope you have a great rest of your day, and we'll see you next week. Take care.